The broadcast is now starting. All attendees are in listen-only mode.
Okay. Good afternoon, everyone. My name is Jenny Faubert, and I am the Editor-in-Chief of Career Education Review. I want to welcome you all to our webinar today on incentive compensation, presented by Ritzert Leyton. Before we begin, I just want to take some time to tell you a little bit about CER. As some of you may know, we have been publishing continuously for nearly 90 years, and actually in January, we will be celebrating our 90th year, so we're really excited about that. What most of you may not know about CER is that we started out similar to an idea exchange group, and that it was kind of a forum for school owners, managers, and directors to share ideas and best practices. So we continue to focus on that and sharing that information with the career education community. And it's kind of one of the reasons why we teamed up with Ritzert Leyton to offer these webinars. And in the future, we will be expanding our webinar topics, and we'll actually be looking to do one on admissions pretty soon, so stay tuned for that. If you're not a subscriber to CER, I hope you will consider to become a subscriber and help us continue our tradition. We're running a special right now for any new subscribers, so if you're interested, please feel free to reach out to me. So now, before we begin, I just want to go over some technical things. We will be recording the webinar, which will be available on the CER website, along with a PDF of the presentation. And that will be, a link to that information will be in an email that will be sent out tomorrow afternoon. If you have any issues during the webinar, please send me a message through the chat function, and I'll try to address that issue. Also, we'll be saving about 10 minutes at the end for any questions, so please feel free to type in your questions in the question function, and we'll ask those at the end of the webinar. If we do run out of time, we will continue a little bit to make sure we can get all those questions in, or we will try to answer those questions through email. Finally, today we are going to be using our poll function. So throughout the presentation, we will be running a couple polls. When they come up, just select yes or no or not sure on your screen, and then we'll read the answers. It's kind of a way to get the audience interacting in the webinar. So with that, our presenters today are Peter Leyton and Ben Walker. I'd like to thank them and the rest of the team at Ritzert Leyton for their continued support of CER. And now I'll go ahead and hand it over to Peter.
Thank you, Jenny. Ben and I appreciate everyone who's tuning in on this webinar, and we appreciate the opportunity to talk about this and this challenging topic as well as others in the future. I dare say everybody on the listening on the call is familiar with incentive compensation and the prohibition in one sense or another. We probably get a phone call or two at least every week to talk about incentive compensation, and some of what we're going to cover today, I think, may be old news to some, but I think we've tried to approach it from a somewhat practical standpoint with these polling questions. Obviously, it's a critical issue to institutions in terms of their operations, or it wouldn't be getting the attention it does get. It's been a high-level focus item for the Department of Education in program reviews and audits for years. It's become a very active area in litigation with False Claims Act cases based upon allegations of violations of the incentive compensation prohibition. And, it can, in fact, become a broader problem in the context of state licensure or accreditation. The department received, for example, a report from its own Inspector General in March of this year, which was quite critical of the department's handling of this issue in the context of its program reviews, essentially arguing that the staff were not devoting enough attention to this issue and were not taking enough proactive approach to the matter. One of the criticisms by the IG was, in fact, the reliance upon what's often referred to as the Hansen memo, which was a memorandum written by Bill Hansen, who was a former high-level official in the department on this subject, and which basically said, in effect, that when there's a violation of the incentive compensation prohibition, the only real enforceable means to deal with that was through fines. The Inspector General disagreed with that, and the department, in response to that report, rescinded or withdrew the Hansen memo, and in fact has, as a result of that, indicated, in fact, that their intent is to not be limited to fine actions for violations. And so, this raises the specter of more action on the part of the department and more serious action on their part with respect to violations going beyond fines. One of the issues in the context of litigation that we see is, unfortunately, the manufacturing of cases. Plaintiffs' attorneys trying to create something essentially out of nothing based upon written policies or alleged practices. So, when you couple that with the government investigations, with the department's presumed increased enforcement action, and I say presumed because, since March and since the department's withdrawal of the Hansen memo, at least I personally, or this firm, I don't think has seen any increased action by the department. But it's something I certainly would expect to see. But fundamentally, the question is, can you manage your employees? Can you compensate them appropriately? And, in the context of an environment where enrollments are difficult, maintaining them or increasing them can be difficult for some institutions, is this something that can be used that will help with that activity?
And so I'm going to talk a little bit about where the ban appears in the regulations. And the regulations at 34 CFR section 668.14, and that's actually recounting what an institution has to do to participate in Title IV as a fundamental matter, and namely execute a program participation agreement. So compliance with the ban is an integral part of your PPA, and violations of the ban can lead the department or a key TAM relator in the context of a False Claims Act suit to conclude with pretty substantial support that the schools violated a material requirement of the PPA, and therefore that all the Title IV funds that were dispersed under that PPA were invalid. And that's found a little bit of traction in the judiciary because it's difficult to tease out which student who received Title IV was recruited improperly and by someone who was paid in violation of the ban on incentive compensation. And so the easiest way to do it is just say, well, since we can't tell, all the money should come back. and that's a real problem for schools. And what's the ban prohibit? Prohibits the school from providing any commission, bonus, or other incentive payment based in any part, directly or indirectly, upon success in securing enrollments or the award of financial aid to any person or entity who is engaged in any student recruitment or admission activity or in making decisions regarding the award of Title IV. And for the purposes of this presentation, we're going to focus more on the admissions part of the ban. We don't see it very often, if at all, on the financial aid side. Financial aid tends to be a much more straightforward activity, and students who qualify receive their funds, and there's really no, or I haven't seen at any rate, a big motivation to pay people in violation on the financial aid side.
So we come, I think, to our first poll question, and it is whether the campus president can receive a bonus based upon EBITDA or profitability of the institution or enterprise. We're getting answers to that question right now, and I guess it looks like about half of the respondents are saying that the campus president can get a bonus based on EBITDA. Our answer is probably, it depends. If you move to the next slide, I mean, any analysis involving this issue, and Ben, can you move to the next slide? Any analysis of this issue of incentive compensation, you know, as the department has said, kind of focuses on a two-part test. You know, is it a commission, bonus, or other incentive payment? The definition of that is very broad. It's a sum of money or something of value. And is it paid based on any part, directly or indirectly, on success in securing enrollments or financial aid? Again, a very broad definition. The analysis that we go through looks at the individual. You know, as this slide says, you know, the ban applies to any employee regardless of title. The question is whether the person is a covered person involved in covered activities, and whether that is what the incentive payment is being paid for. So in the context of the question, you have to ask, well, what is the president of the campus doing, and what is his involvement or her involvement in the student recruitment activity, admissions activity, or financial aid activity. We have clients, for example, that deal with this issue in the context of a multi-campus organization, and that's another part of this analysis of this question, is whether you're a single institution, whether you're a multi-campus institution, whether you have you know, vice presidents, for example, who the president reports to, and whether that campus president actually is involved in admissions and financial aid, or whether that reporting responsibility might actually be to other people. As I was about to say, I mean, we have clients where the admissions people don't report to the campus president, where in fact they report to a vice president, a senior executive in a larger organization. And you know, to try and take away any issue here of the activity on the part of that president being involved in covered activities. there are a lot of factors that go into a bonus based on EBITDA that have nothing to do with the revenue side of that analysis. They have to do with the expense side of that analysis, and whether perhaps the president was able to increase EBITDA because of cost savings in some other way. So I mean, it is there's a basis to argue that if the campus president is getting a bonus based on EBITDA, that even though the admissions staff, that the director of admissions, for example, might be reporting to that individual, it still doesn't fall within the band, because this bonus based on EBITDA is really not based on that factor. And in fact, that president might not be involved beyond a supervisory / policy level involvement, and we'll get into that later in a little more detail. So, I think it begins to become apparent that this question doesn't lead to an easy yes or no answer. And in fact, that's true for many positions within an institution.
All right, we're going to pick up with poll question number 2, following up on what Peter was discussing. The college president was once an admissions rep, so he often turns up in the admissions office. He talks with reps, shares strategies, offers advice, has been known to observe some enrollment discussions. He also sometimes steps in when he thinks a rep is having trouble connecting with a student to talk about the value of a college education. Based upon the college's financial performance, he is looking forward to a bonus this year. Can the college president receive a bonus without violating the ban? So we'll give you a few seconds to get your votes in. This time it looks like the majority of the participants voted no, that would likely be a violation. And I think potentially there could be a violation there. Again, we have to look at the department's 2-part test. The first part of which a monetary bonus certainly constitutes prohibited compensation if the individual is a covered person. And rank, job title, status, what the written job duties are, they really don't have a bearing on the analysis. Instead, Ed's going to focus on what actually occurs day to day with regard to the actual work practices and activities that are occurring. And so in this case, a senior executive or a manager or campus president in this case is not engaged in covered activities if he or she is engaged in what Ed deems or has discussed as policy decisions related to the manner in which recruitment, enrollment, or financial aid will be pursued or provided. And so involvement in exclusively policy-related decision-making is not a covered activity. And in fact, a lot of Ed's focus will be on face-to-face interactions with students or individual interactions with students, but they do carve out in the Dear Colleague letter referenced a few slides earlier that a college president or dean can speak with prospective students about the value of a college education or the virtues of attending a particular institution and not violate the incentive compensation prohibition. What I think the problem is the campus president in our hypothetical seeing a rep having some trouble and sort of coming in to use some of his old skills to help save the enrollment. And even though he may be talking exclusively about the value of a college education, I think the department might take a dim view on that interpretation and would rather, what they contemplate, I think, by their language in the Dear Colleague letter is the campus president seeing a student on a tour and shaking his or her hand, saying, great to see you, welcome to the college, we have some great facilities here, wonderful you're pursuing your college education, have a great tour. And really, we're carving out an exception for really limited interactions that were really more about greeting a student, welcoming them, things like that, as opposed to a campus president sitting in a discussion between an admissions rep and a prospective student. All right, poll question number 3. The new director of admissions wants to energize her staff. She knows she cannot pay bonuses or provide gifts to reps, so she starts a contest. The rep who completes the most interviews in 1 week will receive 4 hours of paid time off. Does this contest violate the ban? And this one's pretty overwhelming already. 80% would say yes. And what I think, again, we have to question, okay, certainly these would be individuals engaged in covered activities. They're admissions representatives. There's really no way getting around that. And then we look at, is this a commission, bonus, or incentive payment? And is it paid in any part directly or indirectly upon success in securing enrollments? Well, one cannot very well enroll students unless one interviews them. And so the most number of interviews conducted is more likely than not going to lead to the most number of enrollments. And so from a purely numerical perspective, which is a lot of how this analysis is done in retrospect in the context of a program review or an audit or litigation, I think what you'll find is typically students who interview the most typically enroll the most. And if you're rewarding those who have enrolled the most, it's certainly indirectly based on their, who have been interviewed the most, it's indirectly impacting their success in securing enrollments. And I think paid time off also constitutes something of value. It's something that these high-performing employees are getting that others are not.
So, you know, we've talked about it a bit now in terms of what are covered activities under the prohibition. And when you look at the regulatory language, it's arguably, you know, extremely broad. When you read the Dear Colleague letter, it strikes me in any event as more reasonable in that the focus is on contact with prospective students, though that guidance, you know, I think suggests or makes it clear that just about any form of contact with a prospective student is going to constitute covered activity, and therefore make that person a covered person. But the coverage, what constitutes, and examples given in the materials, you know, run the gamut from, you know, pre-admission or advising, scheduling an appointment, to visit the enrollment office, or involvement in the signing of an enrollment agreement or financial aid application, not to mention the more traditional activity of an admissions representative with a student. This slide does list what the department has set out as not being covered activities: broad information dissemination, advertising programs that disseminate information to groups of potential students, collecting contact information on prospective students, screening pre-enrollment information to determine if the student meets admission standards, and determining whether an enrollment application is materially complete, so long as the enrollment decision remains with the institution. Ben, I thought you were doing this one.
Several admissions reps at the college do well with their general work duties. That is, they show up on time, they act professionally, they are team-oriented workers. However, even after significant coaching from the admissions director, they continue to underperform in terms of enrolling students. The admissions director would like to terminate these underperforming reps. Would termination violate the ban? All right, and looks like the majority of the people said no. A few not sure, and some said yes, that termination could constitute a violation of the ban. Our firm has tended to take the position that termination isn't something of value. It appears to us in our reading of the regulation and interpretation that it requires the giving of something, money, something of value, and termination is really the ending of a job opportunity. It's not giving someone anything. There's been minimal guidance from the department on this issue, and some plaintiffs' attorneys have attempted to proceed on this theory without a whole lot of success. I know one case I can think of out in the Ninth Circuit, the judge was somewhat incredulous, I think, that you mean to say that you can hire someone to do a certain job that is enroll students, and you're telling me that the school can't terminate them if they don't enroll students? That sounds like a pretty plum job in my view. The only person who has a job that's better is me, because I can't be fired at all as a federal judge. So I think that our firm's view has been that that termination doesn't constitute a violation. However, it can be a tricky issue, and sometimes bears some additional looking or review.
Yeah, I guess I would add to that I mean, it can be an important issue to analyze carefully. Some institutions have approached that by creating two systems, where in fact you have a system methodology to evaluate performance based upon traditional factors of performance, and you have a separate incentive or separate compensation system for those individuals that is run perhaps by different people, different time frame, different analysis, and does not take into account those factors, and in fact focuses on what the department has said is permissible, or on what the department has indicated are standard acceptable evaluative factors. The poll question number 5 is career services personnel want to give small gifts. It's a prior slide, Ben.
Yeah, I'm having a little trouble. Apologize, some technological issues here.
Okay, for example, a $5 Starbucks card, $20 Amazon card to graduates who complete a form listing their job title, employer, wages, etc., which the school uses to report placement statistics. Would providing these gift cards violate the ban? And we have 70% of the respondents saying it would not violate the ban, and I think we agree with that. It is certainly something of value, but it's not being provided or paid based on any part, directly or indirectly, on success in securing enrollment. So it does not meet the two-part test, and you can move forward.
And I think what I liked about that one is it's based on a discrete activity. It's based on completing a form and returning it, a very objective way to determine whether or not someone got this gift or this form of compensation. If they did return the form, they got it. If they didn't, they did not. So suddenly you have a really very clear and objective basis for providing the gift or the something of value. Success in securing enrollments. How does the regulation define activities that are subject to the ban in terms of their success in securing enrollments? And what the regulation says is activities a person or entity engages in at any point in time through completion of an educational program for the purpose of the admission or matriculation of students for any period of time or the award of financial aid to students. And so again, broad language. It would seem to encompass any activity to encourage a student to come back next semester, continue your education. So suddenly you've got a little bit more, potentially some more people at your institution that you may need to take a look at to see whether or not they're covered employees engaged in covered activities in terms of when they're interacting with the student and what they're encouraging that student to do. And the guidance sheds A little light on this topic in defining covered activities that we've discussed before, those targeted information dissemination solicitations, and really those are in the context of prospective students, students who haven't enrolled yet, but as you can tell from that regulatory language, it's potential, there's the potential exists for someone to argue that that someone encouraging a student at a later date who isn't in the admissions department but helping the student, fill out their second, if they have to fill out a new enrollment application or something like that, to continue, might be covered by the ban. And again, the suggestion is that the concern is with direct communications or interactions with students. And this would generally be consistent with the ban's statutory purpose. And when it was put in place, it was to prevent an institution from providing incentives to its staff to enroll unqualified students. So really the purpose of the ban at its heart is to prevent the enrollment of unqualified students. That is just moving them through the system without any care or concern as to whether or not they meet the enrollment requirements at the institution or can benefit from the program. And so here's our next poll question. The admissions director knows about the ban, but wants to motivate his staff. He promises new hires that if they enroll 50 students during their first 90 days, he will increase their salary by $10,000. When the VP for compliance turns into his office, the director says, look, I set that goal so high that nobody can make it. We'll never have to adjust anyone's salary. This proves true, and the school never adjusts any rep's salary by $10,000 because nobody ever hits that goal. Does making this type of promise violate the ban? So again, we'll give a few seconds for people to, he's pretty overwhelming. 90% would say yes, making this type of promise violates the ban. 6% said no, and we had a few who were unsure. And when I analyze it, again, as is typical in these situations, you look at Ed's two-part test. The individuals who will receive the payments are covered persons, they're reps, so they would certainly seem to be engaged in covered activities. And a salary adjustment of $10,000, certainly a sum of money or something of value. It meets both prongs. But I would say, however, no money was actually paid by the college. That is, nobody received a salary adjustment. So does this impact the analysis? I would say yes, it does. And certainly a legal argument can be made that nothing of value was ever given to the covered employees. However, I know that the department would take a dim view of that practice, and I know at least one United States attorney who would also take a dim view of that practice. And their view would be, and perspective is, look, this ban was intended to stop school from rewarding its staff for recruiting unqualified individuals. And if you're motivating them even with a promise, that's enough to violate the ban because it gives someone a reason to go out and enroll people who may not be qualified. And their view would be that's enough. That's enough to constitute a violation. So I think if you're at a point where you're having to debate that with the department, it's not a spot you're going to want to be in. It's not a spot that makes anybody feel very comfortable. So I would say, let's strive hard to avoid those sorts of promises just because of the impression that it gives. And is a promise alone sufficient? Technically, from a legal perspective, perhaps not. But again, if you're forced to be making that argument, you've already bought a problem for yourself.
So that moved to poll question number 7. The campus president wants to buy lunch for staff in the admissions and financial aid departments. She says that all staff in both departments are invited. The school will provide training before lunch is served. Financial aid director says some of his new recruits need to be packaging more students because he is underwhelmed by their performance, and he does not agree to let. He agrees to let more experienced financial aid reps attend, though his underwhelming performers must stay and work the floor. So does prohibiting some of the financial aid reps from attending violate the ban? Wait a minute here. So we have about 49% saying yes, and 39% saying no, and 11% saying not being sure. So if we look at again, the two-part test, is lunch something of value? And we would say it is, regardless of the choice of restaurant. But is this lunch being provided based in any part, directly or indirectly, upon success in securing enrollments or financial aid decisions? And our thought is that under the original proposal, everyone is invited. It's neutral, and therefore we would not have an issue with that. The problem is with the financial aid director's restrictions and the potential for a violation there. Is it a significant item, a lunch? Arguably not. What would the department do in that event? Hard. If that's all that's involved, it's hard to see much of any serious consequence. I suppose the most I could think of that would be serious would be a fine. But I don't know that I would reach an absolute conclusion on it being a problem. But the problem here is that it does raise an issue that the school would have to deal with potentially because of that restriction by the financial aid director, which was contrary to the original plan. One of the covered activities relates to adjustments to salary and the extent to which a covered person is impacted by this, and whether adjustments to salary would constitute a violation. Under the pre-July 2011 regulation, there was a safe harbor which allowed for no more than 2 adjustments per calendar year. With the revised set of regulations eliminating practically all of the safe harbors, the department went to a position stating that an employee who receives more than one adjustment to compensation in a calendar year is considered to have received such adjustments based upon success. So there's a presumption created. It's a rebuttable presumption, but the burden is going to be on the institution to demonstrate a legitimate basis for this. One might be, for example, that the individual was promoted and actually has a new job with a clearly, not only a new title, but clearly demonstrated new responsibilities. Beyond that, the department has indicated in their guidance that seniority is specifically allowed, so that a salary adjustment, and I'm not talking about multiple, but a salary adjustment based on seniority is permissible. It is one of two ways in which salary adjustments are addressed as being permissible. The other deals with standard evaluative factors. I think Ben's going to talk about that.
Right, and those are your other standard evaluative factors: job knowledge and professionalism, analytic ability, initiative and work improvement, and clarity in communications. Things that you would find in a typical office setting in terms of evaluating how the employee does his or her job, interacting with students, coworkers, etc. Excuse me. And I think what we see most often is inconsistency or too much subjectivity in terms of how those evaluative factors are used. If you're going to have a ranking system, you need to be very clear with your managers and very clear in writing the policy if you're going to rate someone on a scale of 1 to 10 in terms of analytic ability, use of the database, etc., how do I earn a 1? How do I earn a 10? You need to have some backup to show why Ben got an 8 and Peter got a 4. You'd need to have some, something like some contemporaneous notes, something that shows you've been looking at these factors in real time and have considered them on an objective basis and haven't just come in at the end of the year and thrown together some ratings that end up being viewed as a sham. And here's a longer list of your other standard evaluative factors that the school may use and that the department has listed out as can be used as an evaluative factor. I'm not going to go through all of them, but you can see them there for yourselves. And what you need to keep in mind is the burden is always on the school to maintain documentation of compliance with the ban and thereby to show it's complying with the PPA's terms. So what you want to think about is there objective data that supports our evaluations, and do the evaluations objectively support our salary adjustments that we made? The easiest way to do it typically is through a band. If you're going to do a ranking system, if you score 80 to 85, you get X% of an adjustment. If you scored 86 to 94, you get X plus, and so on. So that really there's no wiggle room in terms of who gets what. It's based on the ranking number. You add up all the scores and you end up with a final score, and that's how you do it. Alternately, for the seniority point, if a 1 year of time with the company means the employee is going to get an X percentage of a raise, 2 years this amount, 3 years, and really work with a band that's going to allow you to prove objectively that you've given the adjustments based on something other than success in securing enrollments. And you need to be particularly aware that ED's guidance indicates it will take action if it perceives that non-enrollment criteria is used to disguise enrollment-based criteria. Think of words like disguise, pretext, sham. That is, when we look at the numbers, the number of people, the number of students that your reps enrolled is the highest ranking person consistently getting the highest evaluative rankings, even though he may tell someone, I come in late, I don't have to adhere to the dress code, I make tons of mistakes in doing my database entries, but hey, I enroll a lot of people. That's certainly going to look like a sham and look like it's something that was put together after the fact to justify the salary adjustment that person received. And when working with clients, we try to counsel them that to consider our managers applying the same standards to similarly situated employees. That is, do they have a written policy that shows what they're going to rank them on? Are the employees aware of it, and is it applied objectively? Can your managers objectively document the basis for the rankings they give? Some schools can get reports from their database on the number of errors that occurred. That's a real objective piece of data to show who's making errors and why. Again, Jane got an 8 and Tim got a 3. It's because the report showed that Tim had made 4 times as many errors as Jane. Real-time notes or observations are critical. Keep those in writing, and a routinized review process is also very useful. And remember that the department will tend to, or a plaintiff's attorney will reverse engineer your data to see if those receiving high ratings on standard evaluative factors also, coincidentally, are your highest performers in terms of enrollments. So keep that in mind and be aware of it, and try to look at it yourself and see what someone might find if they were to reverse engineer your rankings. And are you consistently finding that your highest performing folks are also getting the highest rankings? And I say that with difficulty, because a lot of times the people who perform the best on their database entries, their attendance, will tend to do well in terms of enrollment. So it's a delicate balance and something that every school needs to be looking at pretty closely.
Yeah, one if I can interject, one thing here that is possibly important in that analysis and the way in which you implement the evaluations to avoid the issue of a sham is possibly, one is the question of how objective are the criteria. If they are, the more objective they are, the the easier it is to work with. And secondly, are the people who are doing that evaluation on the salary different than the people who supervise the individual on a performance basis in terms of the the functions of an administrative rep's job, primary functions. Sometimes that can be created. So then we have 2 poll questions coming up now. We're going to do both polls and then we'll talk about them together. 8 is whether it would be a violation to send flowers to graduates or employers as congratulatory statements or simply thank yous. And we're waiting for a second here. And 93% say it would not be a violation. And poll question number 9 is whether it would violate the ban to provide compensation or a bonus to program advisory board members if they refer students to the school. Now, and the results here are interesting. We have 57% saying it would be a violation, and 36% saying no, 7% unsure. The question, as we've done with other poll questions here in terms of the analysis, is whether the gift provided is something of value. The flowers, questionable whether that's something of value. It's something nice to get. I guess you could stretch that and say it is something of value. The compensation to a program advisory board member or bonus is clearly something of value. But then the question is whether the graduate or an employer is engaged in covered activities if you're just saying thank you. And I think the answer there would be no. So I think the 93% who indicated that was no on poll question 8 are correct. On 9, you've got a bonus being paid to program advisory board members for referring students to the school. You do have something of value, but referring in that context and not doing anything more, not getting a bonus based upon success in securing that enrollment, simply a referral, I don't think would constitute a violation of the ban.
And to interject just a little bit, I really more, in writing that, was considering that the bonus was really for serving on the advisory board. And if it was a bonus given to every advisory board member, regardless of whether he or she referred anybody or that person enrolled, then certainly there's an objective basis for doing it. Did you serve on the board or not? If you did, you got it. If you did not, you did not receive the bonus. And in that case, I think you have some clearly objective information that it was not directly or indirectly based on success in securing enrollments. But Peter does raise a real good issue on that one, that just a referral wouldn't seem to be enough.
Unmuted. Because
just the referral is not success in securing an enrollment. After that point, after the referrals come to the school, it's really been handed off to the school and to do with what it will. And if the school is giving the bonus regardless of whether the person enrolls or not, I don't see how you would ever end up with a violation.
I think we talked about these future challenges at the beginning in terms of the Hansen memo, this subject area of incentive compensation generally in the context of the department and litigation, False Claims Act litigation, whether it's the Department of Justice pursuing a case, or state attorney generals, or private litigants who are called relators in FCA cases. The overwhelming majority of issues raised in those types of cases and actions have been based upon allegations of violations of incentive compensation. And in those cases, the amount of money being sought is huge, because it is so hard to connect a particular violation to a particular improper action. And so the argument is that the institution violated the program participation agreement by violating this ban, and therefore should return all of the funds dispersed during the applicable period, whatever that is. And what concerns us now is, with the rescission of the Hansen memo, is that the department will take a more aggressive approach towards enforcement in the context of its violations of this ban, not to mention the fact that we're concerned and believe the department will take a more aggressive approach in the context of their program reviews as well. So I think, sorry, go ahead.
Further consider that the False Claims Act provides for treble damages. So suddenly you have all the Title IV dispersed under the PPA times 3. And that can become the measure of damages at the end, and that number adds up extraordinarily quickly.
Yeah. So, Jenny, I think that ends the formal presentation. I don't know if you have some questions.
Yes, we do have a couple questions. So let's go ahead and start those. And if you do have questions, again, just go ahead and write them out in the question function. Let's start in the beginning. So our first question, the preamble indicates retention, completion, graduation, or placement are in violation of HEA's prohibition on payment of incentive comp. Thoughts on that?
Ben, do you want to answer that or address that?
I would want to check the language. I certainly wouldn't think that placement, success in helping students find jobs would be subject to the ban. I don't see how that falls into a covered activity, simply because it has nothing to do with success in securing enrollment or an award of financial aid. So I certainly don't see how the department will reach a conclusion that employees in, for example, career services department or placement department would ever be subject to the ban. Assisting students in finding jobs prior to or subsequent to their graduation would not seem to me, based on my understanding, to fall under, to bring the person into the ambit of covered activity. So I wouldn't think that those individuals would be subject to the ban. And certainly,
if the questioner is referring to the preamble to the Federal Register regulation, I'm assuming, and I don't believe that is a correct representation of what's in the preamble.
Okay. Let's go on to the next question. Are cash program schools not participating in Title IV programs included in the ban if these schools' revenue will be counted towards 90/10 for the entire company that has schools participating in Title IV? That's a long, difficult one.
Well, the ban applies, as we said in one slide, to any person or entity which is engaged in any student recruitment or admission activity for that with respect to that institution. So if the schools being referred to are in effect a separate operation, no Title IV being received by those students or the school, that school, it would seem to be separate, and this particular ban would not appear to apply there. Now, one thing though is, what's the relationship between that subsidiary, I would guess, and the Title IV institution, and do most of those students in that subsidiary go on to the Title IV institution or not? If in fact a large percentage do go on to the Title IV institution, I think it would raise a problem.
And Peter, would you be looking at which institution has the PPA, what the OPID number, facts like that, to establish who's subject to the ban and which is not?
Yes, sure. That would be highly relevant in terms of that. So, I mean, at least as I heard the question, it sounded like it was an affiliated group of schools. They're within the OPE number in order to count the revenue as 90-10. They have to be. But those students are being recruited for non-Title IV programs. And I guess you would have to also look at who's doing the recruiting for the non-Title IV programs. Is it a separate group of recruiters, or is it the same group that recruits for the Title IV institution? That could present an issue as well.
Okay, next question. I think this was from one of the earlier slides. What about the president approving or disapproving an admission? Which way would that go?
I guess the question would be if the campus president would hinge on whether or not he's determining whether an application is complete and someone's meeting the eligibility requirements. I think if you're looking purely at that, does this person meet or not meet our eligibility requirements, I don't think they would fall within the ambit. I think there is an exception for that. But again, it's gonna be pretty fact intensive, or is it a question of sitting in with an interview of the student and determining based on that whether or not this student's a good fit? That's more likely to be considered someone who's engaged in a covered activity. But I think if it's purely sorting the applications to say this person meets the admissions criteria, this person does not, I believe there's an exception for that.
And how about a campus president that manages the direct marketing efforts of the campus, i.e. the flyers, newspaper, SEO, ads, etc.?
I would say, and Peter, you can correct me if you think I go astray, I would say generally that's going to be an exempt activity because it's broad information dissemination to large groups of people or large groups of prospective students. So really it falls more under more into a policy setting or a specifically exempt activity because it's a broad advertising campaign, a broad marketing campaign. It's not much of specific involvement with or interaction with specific students, specific individuals. Now, certainly, you're going to have people who go out and implement that marketing plan and may present at high schools, may present at career fairs, things like that. Those individuals would be subject to it. But the person who is sort of creating, who is driving or assisting in the creation of the creative portion or setting, here's where we're going to go to do our recruitment activities. Here are the activities we're going to participate in the local area. Setting those tend to fall more under a policy setting, the policy setting exemption.
I think that's right.
Okay, next question. We have quite a few coming in now. What about paying existing students for referrals?
I'm sorry. Say that again?
says, what about paying existing students for referral?
Again, Peter touched on this one earlier. Is the payment purely for the referral, or is the payment only, or does the something of value only become payable upon the enrollment of that student? If it's purely for a referral, I do not think it would be a violation because it has nothing to do with the success of securing the enrollment. And I know I've given some advice like that in the past. And I think you would also be fair to set some limitation on that. And what I mean by that is a referral, the sum of value of this gift card or whatever it may be, will be given upon a provision of a valid referral that the institution can document is a real person. And why do I say that? Because we've certainly had attempts in the past for students who have submitted referrals for Mickey Mouse and Donald Duck and Bob Marley and any number of other individuals who do not exist, and tried to get their gift card for that. So I think it's fair to set a requirement that we have to be able to verify it's a real person, but as long as the payment has no connection to whether or not the person referred enrolled, I think that would be a valid payment. Doesn't violate the regulation.
Yeah, though I think if that was going to be done, or it would be better practice to keep the payments to a small or de minimis amount.
So this seems to bring up a couple of questions, the referral. So I'll read another one. I thought that referral bonuses paid to students was eliminated with the end of the safe harbors. Was it not?
Well, yes, there was a safe harbor that did address that, and there are no more safe harbors. But from the standpoint of the analysis that needs to be applied to this type of an issue, again, is it something of value that's being paid for a covered activity? Covered activity does not include per se referrals. The department, I think, does frown upon it, but we don't think there's any explicit prohibition on that.
Again, primarily because you've disconnected the success in securing the enrollment from the payment. It has to do with something entirely different. But as Peter aptly notes, I think it tends to be frowned upon.
Okay, let's go to the next question. Is there a violation to pay lead vendors based in enrollment rather than pay per qualified lead?
Yes, that would be a violation if it's based on enrollment.
Okay.
Because as in opposition to the prior hypothetical, there's a direct link. If the student if the student enrolls, the lead generator is paid X. If the student is not enrolled, the lead vendor does not get paid, presumably, or gets paid less.
This is one of those areas where, in fact, the current regulations are pretty clear about that, and they've created an exception to allow for the payment to vendors, to lead generators on a per capita basis, but it can only be for providing that contact information, basically. The problem here that can arise is when the lead generator does more than just pass on information. And that entity or those people start getting involved in actually trying to persuade a prospective student to go to X school, or evaluating, helping those students to make decisions, then in fact you're going to have a problem.
Okay. A couple of people asked if we're recording the webinar and if the PDF will be available. It will be available on the Career Education Review website, and we'll have a link to that in the email that we send out tomorrow. It was also asked if we could distribute this presentation and give the answers to the poll questions. We'll look into seeing what we can do about that. We are going to have this written up as an article, so that is someplace that we will probably have the answers to the poll questions. It'll be in the next issue of CER. Let's go on to the next question. Would a monthly celebratory dinner for top enrollers be viewed as a violation?
I think the potential certainly exists. It's something of value that only the top performers are getting. It's not given to celebrate the entire department's achievement, and everyone's invited. Really, in my experience, that's where I see problems arise when you've got a segment who are allowed to participate in X, Y, or Z activity, and another segment that is not, and the basis for the participation is how successful they have been. You know, I can, if you could disconnect the basis for the for your presence or your invitation to come to the dinner from success in securing enrollments, potentially it wouldn't be a violation. You know, if it was given to the top performer in the rankings at every department, maybe that's a reason. And one of the ranking criteria was not number of students you've enrolled, then you've disconnected it, such that you know, someone who doesn't enroll very many people but is very professional, dresses well, shows great teamwork, interacts well with coworkers, interacts well with prospective students, does a good job on database entries, all that other stuff, your standard evaluative factors. If they could go as a quote-unquote top performer, then it's disconnected from success in securing enrollments. But it becomes a pretty fact-intensive review, and you need to be looking at what's the basis for allowing this portion of the staff to go and excluding that portion of the staff. And when that happens, what I've seen it create is distress and anxiety amongst the staff, and then down the road that can lead to complaints and give rise to, or, you know, for example, an FCA action or something like that by an employee who's left disgruntled. They think back to how angry they were that they were excluded from this luncheon or didn't get to go to that event, and suddenly they remember a lot more awful things that happened to them.
Yeah, I mean, this is certainly one of those examples where, you know, neutrality is really and the guidance really, I think, goes in this direction too, that the neutral approach is preferred. So, you know, again, it's a celebratory lunch or dinner, but it includes everybody. Would be, in my mind, a better way to go. Safer, anyway.
So are non-Title IV schools exempt from the ban, or does this apply to all schools?
Oh, no, this applies to all schools. Which is, you know, I'm glad someone asked that question, because there are a lot of non-profit institutions that seem not to realize that this applies to them as well.
During the presentation, you suggested that terminating an admissions representative because they were unsuccessful in securing enrollment was probably not a violation of the ban. Have you ever seen termination or write-ups as being in violation?
No, we have not. You know, we had. I remember when the regulation was being when it was during the negotiated rulemaking phase, and maybe even a follow-up after that. You know, sending the department, and I think others did as well, a question in writing with respect to that point. And to my knowledge, no one's ever received an answer from the department. But as Ben said, I mean, there is case law that supports it, and I think a reasonable analysis of the regulation itself leads to the same conclusion. I mean, these are not lifetime appointments.
And Peter had raised a point sort of in the early going there, that this was some clients have put in sort of a two-part system. They have their annual evaluative factors that do not include success in securing enrollments as a factor, and that's used to determine whether the employee will receive a salary adjustment. And they do an entirely separate analysis of their success in securing the enrollments and how well they're performing in terms of an objective number, and that's used to determine whether or not the person is going to remain as an employee. And we've seen some clients use that sort of a system because, as Peter said, these are not considered lifetime appointments. And if you're not doing the most basic requirement of your job, I don't know. It'd be a great job to have, certainly, but I don't think that these are intended to be lifetime appointments.
Okay. May I ask for the name of the case which set the termination precedent?
I don't have it handy. I can, if you email me, I can look it up for you.
Is employee profit sharing covered by the ban?
Is what?
Employee profit sharing.
Oh, profit sharing. There is actually a carve-out, and for that issue, the department has said that a neutral system, which is objectively based, such as a 401k plan, though, or other profit-sharing plan, is permissible. Yes, it's not covered by the ban.
And that
it
you'll find.
I'm sorry.
You'll find that in the Dear Colleague letter, Gen 1105, and Peter quoted the language almost exactly. It says profit-sharing plans, including 401k type plans, from which distributions are made to individuals on a basis that is neutral with respect to the role the recipient plays in student recruitment or the securing of financial aid, would be considered by the department not direct or indirect payment of incentive compensation.
But if that plan were only for the employees who are admission reps, that would be a problem. We're talking about a plan which is, typically I think would be at least institution-wide, if not company-wide.
And similarly, you couldn't be, I don't think, differentiating amongst admissions employees at the same level. Your profit sharing percentage for your director of admissions would likely be higher than for an admissions rep, but it couldn't be higher for admissions rep A and lower for admissions rep B. It would almost immediately raise a question, why is A getting more than B in your profit sharing plan? So really what you're looking at again is a method to band employees such that everyone at this level gets X percentage, everyone at this percentage would get Y, everyone at this level gets Y, and something that really, when you look at it, is objective and can't be, it becomes more difficult to attack as being based on success in securing enrollments or securing a financial aid.
So we have probably about 10 more questions. Would you guys like to stay on and keep answering, or should we?
Jenny, unfortunately, I have to move on. I don't know, Ben.
Yeah, I can stay on for a little more time, and if there's anything that causes me any concern or any heartburn, you can just email me the question. But I'll be happy to do my best to answer the questions that are still out there.
Great, then we'll thank Peter for your time, and then we'll just answer some of these questions.
All right, thanks a lot. Bye.
Thanks, Peter.
Okay, so the next question, does the ban on incentive compensation apply to recruiters who are recruiting only international students who would not be eligible for Title IV funding?
No. There's a carve out. Let me grab my little reg book here, and I can tell you what it says. One moment. It's actually 34 CFR 668.14 B22 1 Romanet 1A. The restrictions in paragraph B22 of this section do not apply to the recruitment of foreign students residing in foreign countries who are not eligible to receive federal student assistance. So as long as the students being recruited were foreign students residing in foreign countries who are not eligible to receive federal student assistance, that is Title IV, the individuals who are recruiting them are not subject to the ban. And we have clients who have exclusively international recruiters. They can be paid bonuses. They have been without any concern thus far anyway. I think that's a very specific carve out. But again, you have to be very careful to make sure that those recruiters are only recruiting international students. And the way, the easiest way to handle that is the recruiter gets information on those 3 questions up front. If there's any concern that the student may be eligible, they immediately get transferred to a domestic rep, and they could always go back, be transferred sort of back and forth. It becomes a little bit unwieldy, but generally speaking, the institution's able to do it, able to differentiate who's foreign and eligible for Title IV and who's not in relatively short order. And if they're not eligible, you can pay for recruitment of those students on whatever basis you want.
Great. Next question. Can an executive level leader be compensated for the institution's success in meeting student persistence goals?
Is the individual engaged in a covered activity? Becomes, I think, the determinative issue. Because if not, then you've delinked, that individual is suddenly exempt from the ban. Again, if you look at the Dear Colleague letter at Gen 1105, you'll see they've got a little table and covered activities, exempt activities. If you're not engaged in a covered activity, excuse me, then presumably those are not activities subject to the ban on incentive compensation. Otherwise, I think if the person is engaged in covered activities, persistence, you can't very well persist if you haven't been successfully enrolled in the first place. And so I think at a minimum there's an argument to be made that that's a proxy, or it's at least indirectly related to success in securing the enrollment, and so that becomes the problem there, or the potential problem there.
So
I haven't seen it litigated, but I think that the department could certainly make an argument with a straight face that it's really that persistence is serving as is indirectly related to success in securing enrollments.
She also said that the individual is not engaged in recruitment or financial aid awarding activities.
Then I don't see how that person becomes subject to the ban in the first place. If you look at the 2-part test sort of in reverse, or the reverse of the way it's been presented by the department, is this person engaged in covered activities and therefore a person covered by the ban? It seems to me if they're not engaged in any enrollment related or financial aid activity, then the answer then no. But again, you've really got to look carefully at exactly what the person's doing and confirm that that it's not related to whether or not, as we read the sort of broad regulatory language, it's not related to the student. They're not assisting the student return next semester, that sort of thing, because then you get it becomes a little bit more tricky in terms of the analysis, or the potential for the department to make an argument that really it is a covered activity.
Then we have another question. Does this apply to the public sector? I believe Peter said it applies to all institutions.
Yeah, I believe it's pretty broad. Any institution with a PPA, certainly.
Direct,
There's no carve out for a nonprofit or anything or a for profit or anything like that. It applies equally.
so directors of education or student services coordinators who are actively calling previously enrolled students to re-enroll, are they considered covered activities?
I believe they would be, because what you're doing is trying to get a student who suddenly you're trying to get a student to re-enroll, and re-enrollment is really synonymous with enrollment in the first place. So yeah, the potential certainly exists. Um, I think student services that I've seen that tend to be there as an academic resource for students to assist them with their scheduling, help them, if they're having trouble with their, I don't know, accessing student support activities, things like that, tend to be more traditional student services activities in the broader sense or traditional sense. Then I don't think those folks would be engaged in covered activities. But if you're actively calling people who are not attending in the hopes that they will come back and attend, then I think you would be engaged in a covered activity, to the extent you are not doing so merely to collect their information so someone else can do that job. If you're touching base to say, hi, this is so and so from the Walker School of Technology, I'm calling just to make sure we had your proper contact information. I saw you attended back in 2013, and wanted to have someone here at the school get in touch with you. Can I verify your contact information is as follows? I'll have someone follow up with you. I think then an argument can be made that really all you're doing is getting student contact information, and you wouldn't be engaged in a covered activity, because collecting contact information is considered by the department exempt activity. But if you're going any way beyond that, in terms of encouraging the student to come back, hey, it's been a long time, we've done some great upgrades to our program, our campus is really looking great, you should see what we've done with the services we can offer. We've really got some great new instructors. You ought to come back. Once you start getting into those sort of discussions, you're really, I think, engaged in a covered activity, because you're soliciting an individual face-to-face, or directly soliciting an individual.
Would a trophy be considered something of value?
It's a good question. I think not, because generally speaking, what value does a trophy have on the open market? I would suggest it's de minimis at best. I don't think many people are interested in a trophy, bidding on a trophy on eBay or something like that. But again, you have the potential for a concern insofar as are you creating an environment that is reinforcing this sort of an enroll at all costs sort of mentality, which is what the department wants to not have anyone engaged in. And but otherwise, I think the department would have a hard time proving that giving a trophy to someone is something of value if with it there was no monetary value associated with it. If it was sort of like the traveling award, and this month so and so, like the Stanley Cup or something like that, this month so and so had it, and next month this other person had it, I don't think that would be anything of value, particularly because you're keeping it for only a limited period of time. It's not yours to keep. It's just there to show that the institution recognized your stellar performance. I think that's falls, I think, more along the lines of something that the department potentially could frown upon and encourage you to, and might suggest you cease doing, but I don't think it could be construed as a violation giving rise to a huge fine or something like that, a termination action, anything along those lines.
Okay. Can any kind of compensation prize be given to admissions reps for changing behaviors? For example, if I am trying to train my admissions reps to not say the word program during phone conversations with students, can I have a contest that the admissions rep that says the word program the least amount of time during a phone call receives a gift card?
I think so, because you've decoupled the reward for anything that has to do with success in securing enrollments, unless the department could go back and reverse engineer it and show that instances where admissions reps did not use the word program resulted in students enrolling a higher percentage of the time. I think that'd be very difficult and time consuming, but again, it would appear to me, based on the facts you presented there, that the reward is not directly or indirectly based on success in securing enrollment. Instead, it's directly based on whether or not you said program. The regulation is pretty clear on that point. The institution will not provide any commission, bonus, or other incentive payment based in any part, directly or indirectly, upon success in securing enrollments or the award of financial aid. It certainly doesn't say based in any part, directly or indirectly, upon use of certain words or a failure to use certain words or things like that. So I think that you've decoupled it from the success in securing the enrollment. Certainly, as always, an argument could be made, right? That hey, what the school's done is looked at what allowed admissions reps to recruit students more successfully, i.e., not saying the word program, and therefore those who didn't say the word program were more likely to enroll students, and therefore it's indirectly based on success in securing enrollments. But I think that hypothetical is a bit of a stretch. I had to go through some mental gymnastics just to put that together right now, so I don't think that would be a very reasonable argument to put forward myself.
We have a few more.
Sure.
If career services personnel are an integral part of the admissions tour process, would sharing graduate success employers who have hired be considered a covered activity?
Sorry, say that again. Would sharing
graduate successes and employers who have hired be considered a covered activity?
It could be, insofar as it's targeted information dissemination to individuals. However, I think that's a bit of a stretch. Because I don't think that ultimately the proposed compensation for the career services person is based directly or indirectly upon success in securing an enrollment. Or I would hope not. If you're rewarding them for success in securing enrollments, then suddenly it's easier to argue that they're engaged in covered activities, because their role in the admissions tour process becomes an integral part of the successful recruitment of students. But I think if you're having students, some students, and I presume perhaps it's not every single one, come in and, hey, here's a admissions rep might say, here's a career services rep. They can give you a lot more information about what career services opportunities we provide. The rep then leaves, and the career services gives the information out. Hey, here's some graduates who've had great success. Here's what they've gone on to do. The rep comes back and picks them up, and they go on about their way. I think a good argument can be made that's not a covered activity. It's part of they're giving some career services information to make sure that the admissions rep doesn't misspeak about it. But it really, I need to look at that one a little bit more specifically before I could give a completely firm response. But I think just out of the box, I don't think typically career services folks fall into the ambit of the prohibition of the ban.
We have someone asking if we can forward them the link to the Dear Colleague letter. So we'll try to.
Sure, it's real easy. If you just Google GEN like the word general, first three letters, GEN-11-05. It should pop up right away, but we'll be happy to share the link.
And then
it's dated March 17, 2011, just for your edification.
and someone was asking, where's the definition of incentive compensation in the text of law?
It's going to be 34 CFR, section 668.14 B, 22 Romanet 3, and so that's III, and that's A. So it's 34 CFR 668.14 B, 22 Romanet 3A, and it's gonna read commission, bonus, or other incentive payment means a sum of money or something of value other than a fixed salary or wages paid to or given to a person or an entity for services rendered.
Great. Well, I think that's all we're going to answer today. If we did happen to miss your question, please just send us an email, and we'll try to get to it. I know someone did ask if they can get notes on the questions and answers. We'll look in to see what we can do for that also, and I will let everyone know through email the progress on that.
And Peter and I are here. You can shoot us a line, and we can either respond to your question or let you know that we can't, and here's how we could, what relationship we need to engage with y'all to give the advice you need. Again, all this stuff is really fact intensive. The devil is always in the details. So just I'm happy to serve as a resource for you, but can't promise I can answer every single question you may have.
Great. So before I end, I just want to let everyone know our next webinar will be on November 12th with Ritzert Leyton, and it will be on the 90-10 rule and compliance. So hopefully you can join us for that. And I just want to thank you all for staying on the extra time, and have a great day. Thanks.
Thanks very much, everybody. Have a great afternoon.